But the jury don't hear about them kissing pub, they don't hear about them holding hands, they don't hear about her pulling him into the toilet, they don't hear about the pub report. The CCTV is doctored so that you only get it from later in the night when you see her staggering getting in a taxi. The witness statements are dropped. His statement is redacted. Her statement is either dropped or redacted. So all of this evidence about what actually happened on the night is dropped. They knew that initially they'd put the toilet sex as rape, right? Because if you can't remember the evening, this is obviously not consensual, so that's part of the rape charge as well. But then when they saw the CCTV footage and all the eyewitness accounts and so on, they said, oh, we'll just drop that, right? So we'll drop any mention of that so we can get rid of all that evidence.
This also hurts genuine victims because it casts aspersions over convictions. It raises the doubt that, possibly at some point in the future, those convictions are going to be overruled.
The idea essentially is that the public are sexist and they've got backward views and they don't have the sort of victim empathy that a modern person should have. If you are speaking on behalf of the victim, you are untouchable and you will not be allowed to speak against it. And if you do question it, you will be destroyed.
Today I'm joined by Stuart Waiton, who's a Scottish academic speaking in a personal capacity about a threat to a fair trial in Scotland following the passing of the Victims, Witnesses and Justice Reform Act in September. Stuart, do you want to just give us a rundown of what this act is and how it affects the trial system?
Well, it's not so much this act. The problem is more that over the last 20 to 25 years in Scotland, there has been a change in how the courts operate. Right, so this starts. I don't know how long you want this to ramble, but I'll just go right.
So the act is just like one part of the whole sort of slide, right?
Yeah. No. So in 1985, in fact, it started early in the 70s, but 1985 they start to be concerned that lawyers are badgering women in rape trials. And you talk to lawyers, and there seems to be a sentiment that there's a truth to this. So, in other words, a woman turns up. She says she's been raped, and the lawyer does everything they can to humiliate, paint her as a loose woman, and so on. And so it's like she's being raped again, kind of thing is the idea. And they're saying, well, this is a concern. Judges are allowing this. There's far too much freedom being allowed to humiliate the woman in these questions. So what we need to do is we need to develop what we thought known as rape shield laws and practices. And these are there to limit that type of humiliating, embarrassing, unnecessary, degraded type of questioning. So that by 1995, we developed this process called Section 274275, which basically tries to limit. You have to go to a preliminary hearing, just could be between 6 months and a year before the trial. And you have to say to the judge, these are the questions we're going to ask. And the judge will then assess whether they think they are relevant, right? Or do they think that they fit within the framework of this is unnecessary, degrading, humiliating, and so on. So that's 1995. That was updated in 2002 to sort of expand it a little bit. And then what happens is you start to get, and this is in the UK as well, it's more general, but you start to get parliaments asking academic feminists to assess the rape trial framework. So in Scotland, you'll have one piece of research funded by the government, and then another, then another, then another, and they're all from academic feminists. And the academic feminists all say the same thing, essentially. You're still allowing too much evidence. You need to restrict things more. And at the same time as this, you start to get.
And when you say too much evidence, this is evidence that they think is traumatizing for the complainant to have to divulge in court. So they want to restrict the amount of evidence, to restrict the amount of context, to reduce the sort of personal pain for the complainant.
Yeah, personal pain, and also if it's seen as being irrelevant, right? That this is just an irrelevance. I mean, there's other dimension to this is that at the same time you're starting to get pretty much an acceptance that the public has this thing called rape myths, right? So rape myths, again, it's feminist research that is extremely problematic. I've written a paper on this, extremely problematic. But the idea essentially is that the public are sexist and they've got backward views and they don't have the sort of victim empathy that a modern person should have. I mean, I could explain more about what that is. But anyway, feminists do this research and they say, this is definitely true. We've got rape myths. The public have rape myths. Now, that becomes adopted by the criminal justice system. So the recent Supreme Court ruling on this issue basically described, would use the term rape myths, and the defense people and the judges would constantly use the idea of rape myths. Like it's just a fact, right? That the public believe in rape myths, which is why you ended up, it was last year, just over a year ago, the Scottish government tried to get rid of juries in rape trials, or at least they wanted to have a pilot project to get rid of juries. And that's essentially because they says, well, you can't really trust juries because they believe in rape myths. So we need judges only, right? So one of the most fundamental...
So this is... Yeah, absolutely. And this is kind of like a microcosm of what's happening across Western society, where the public are deemed to not be competent enough to make decisions. So you need experts. You need experts that are handpicked and chosen. But of course, the experts then turn out to actually be activists who've inveigled their way into roles, and so then you've got a very extreme biased activism guiding things instead of the demos, instead of the people.
Yeah, I mean, that's part of what I look at, is try to look at sociology of the new elites and who are the new elites. And as you say, it's the kind of, a lot of the discussion is about the expert class, professional managerial class, and so on. But anyway, so you start to get this push, which is remarkable, the idea that a government, because what they're essentially saying is, hey, you Scottish people, you're bigots, you're deplorable, you're too deplorable to sit on juries. I mean, that really is the essence, as far as I can see.
They've got a point.
Quite elitist perspective about the public, I would suggest, in this process. Anyway, that didn't go ahead because the lawyers basically said, well, we will go on strike, the defence lawyers. Like they said, juries are a foundational part of democracy and law, and they just upped down tools, essentially said this can't happen. So the government withdrew, right? So, but that gives you a sense of the perspective from the people in authority about the public, I think. And again, so the worry is that they have is that if you have juries hear too much evidence, then their prejudices will kick in. So that in a sense, I think, is another push to try and limit the evidence that's taking place. At the same time, you also have a push for increasing the conviction rate in rape cases. So you have this, again, it's part of the sort of feminist narrative. Not all feminists have to say, it's kind of what people describe as victim feminism. So particularly victim narrative promoted by feminists that suggests that the conviction rate in rape cases, which is around 50%, is so low, and it's so low because of rape myths, right? It's because of the juries, because they're backward and they don't give it. I mean, as it happens, I was at a talk with Thomas Ross, KC, who's one of the main defence lawyers, who's come out and said, you can't get a fair trial in Scotland. So he will no longer do rape trials, right? Because he says it's a waste of time. He's just demoralised by the whole thing.
So lawyers are actually backing away from defending rape trials altogether, which, I mean, again, is going to be an extra... I'd imagine that some of the lawyers that are left are perhaps not as good as the ones that are leaving.
Well, that is a potential problem. I mean, I don't know how extensive it is, but Thomas Ross certainly refuses to do it, and he's constantly made the point that it's just the evidence restrictions, and he gives examples of the various evidence, which is where I heard the stuff about the Andrew Keir case. But as he says, the idea that the conviction rate is too low, he says, well, I don't know what that means, because 50% for him, he thinks, well, actually, if you haven't got much evidence, in fact, usually no evidence other than one word against another, then 50%, who's to say what is low or high? Because, in a murder, there's all sorts of evidence. You start to describe these 8 forms of evidence in his recent murder trial. Whereas in rape trials, he says there's often none. And so 50%, who is to say that this is too low? But anyway, the senior people in the criminal justice system and politicians were pushing for conviction rates. So there's pressure on the judges then as well. And there's part of, I think, which is what I'm more generally interested in, is there's a kind of new victim sensibility, which is you are a good person if you empathize with victims. And this has become it's not just a virtuous thing, it's almost a new etiquette and the correct way to be and to think. So what you start to get developing in courts is a situation, and you see this in the documents, they start to talk about the woman as a victim. Right now, which
is sort of prejudicing. That's implying guilt of the accused. If you're talking about a victim instead of a complainant.
Yeah, that's exactly it. So it's complainant in Scotland, by the way.
All right.
Complainant rather than complainant. But anyway, yes, you're absolutely right. That is the point, that if you start to think of the woman standing in that court as a victim and treating her as a victim and acting as if she is a victim, then the trial is, you might as well not have a trial, right? Because you don't know if that person is a victim until after the event. And so you've had all sorts of mechanisms and new frameworks, laws, definitions of rape and so on. So for the last 20 years, there's been one thing after another after another. Now, I can understand that there is a difficulty if, you imagine someone's been raped and they turn up in court and they're being pushed, they're being cross-examined and so on. I mean, that is an extremely difficult thing to deal with. I think that's true. But at the same time, it's also true that you need to be able to do that without you should be able to have a sense that you can do this without nonsense being raised, without any form of humiliation and so on. So you should be respectful and professional. But it's become so one-sided with all these different dimensions of what's happened in politics and within the criminal justice system that you end up in a system where more and more evidence has been limited. And there's other things as well. They're changing the size of the jury. They're getting rid of the not proven verdict because, which I'm no fan of particularly anyway, but they're getting rid of that because they think that will increase conviction. So they're basically self-consciously doing everything they can to increase convictions. Now, it's obvious in that process to me, which is why I started to look at this, that there is the potential that you're going to have miscarriages of justice and you're potentially going to have massive industrial scale miscarriages of justice. And the Supreme Court ruling, which just came out last week, which I actually disagree with as much as I agree with, has made the observation that it does look like Scotland has now moved to a situation where they are systematically blocking almost any evidence to the extent that you cannot get a fair trial in Scotland. And, I keep saying this, and I don't know if people will listen eventually, but I genuinely think this is the biggest legal scandal in Scottish history. You have got potentially hundreds and hundreds of men in prison who have not had a fair trial.
Well, in fact, I believe a member of the Scottish Parliament even said it was acceptable for innocent men to go to jail if it increases the conviction rate, which seems like an insane approach to justice. I mean, this is like the approach that was taken with the Guildford Four. This is like just getting bodies and put them in jail isn't solving a problem or providing justice.
Yeah, I think his exact quote was something like, if one man in 100 is innocent, that's a price worth paying. And of course, the irony. Yeah, well, I hope I wonder if he would feel if he was that man. But of course, the irony is that I think it was Benjamin Franklin said the exact opposite. When you actually used to have a sense of liberty, he said, "You'd rather 100 innocent men go free, you'd rather 100 guilty men go free than one innocent man be imprisoned." And that's because the kind of liberal sense of freedom, liberty, and its relationship to the state understood that the state is incredibly powerful and incredibly dangerous to the individual, which is why in a court of law, brilliantly, I think the essence of law and courts is one of the greatest modern achievements. So you have this idea of beyond all reasonable doubt. So it's not, do you think this guy probably did it, whatever it is? It's, are you beyond all reasonable doubt? You're sort of 95%, plus that you are sure that this person, and only then can the state act. So an innocent until proven guilty, right? All of these things were established because you realize the state has got enormous power. But what's happened today is that the state doesn't act as the state acts on behalf of the victim, right? Or that's right. The representation, right? So it doesn't present itself as we stand for the people. They now say, well, we need to protect victims. We are here to look after victims, we are, etc. So the whole criminal justice system over the last 20, 30 years, David Garland, one of the most famous criminologists, writes about this, talks about the crime victim as the kind of universal type now. This is how the state is starting to operate in the framework where you start to treat more and more people, and ultimately everybody as a victim of some description. And so that's what's happened. So you now have a criminal justice system focused around the victim, and of course, the power then is represented as being caring, because you're just trying to protect the vulnerable. So this is my obsession. Yeah. My academic obsession is, I think, the modern elites, if you wanted to sort of put a stamp on their head of what they stand for, is we protect the vulnerable, right? And that is a new form of moral goodness and a new type of awareness. And in the context of the criminal justice system, as soon as you start that as the opening gambit, the potential for undermining the classic system of justice is extraordinary. And say that's what's happened in the Andrew Keir case, which is in Dundee where I live.
I was going to say, this is a specific case that you mentioned in your Spectator article that was in the Spectator. I think it was yesterday. And yeah, this really sort of, if you want to just talk us through this case, because this really shows it in stark contrast.
Yeah, tragically, the Supreme Court ruled that this was a fair trial, which just kind of goes to show that I'm not convinced that the Supreme Court ruling is going to make that much difference. But anyway,
and this is the Supreme Court in England. So Scottish trials, once people have exhausted the appeals in Scotland, it then gets kicked to the wider UK court.
Yeah. So Andy Keir case, he was a pub owner of the Brewer pub in Broughty Ferry, if people know Broughty Ferry in Scotland. Anyway, it's just outside Dundee. He goes on a works night out, goes around the pubs, and the story that is told in court is started about later in the night. It shows him getting out of the pub with a woman. She's staggering, he's staggering. They get in a taxi. They go to his house, and she falls asleep. She's intoxicated. And then he climbs on top of her and starts to rape her. She shouts no, runs away, and phones the police. So that's what you hear. Right. Now, what happened before this is that the two of them are seen in various pubs kissing, holding hands. There's people witness this, there's CCTV coverage of this, and she beckons him to the toilets where they stay for, I hadn't realised reading the judgment, it's like 30 minutes. She goes up the toilets, then they go to the disabled toilets, and it's assumed they have sex. They get thrown out of the pub because of this. There's a pub workers report about it. They continue to hold hands. She's sucking his thumb in one of the pubs. So there's a kind of, they're having a sexual night. And she says to the police in her interview, I would never have sex with this man because I don't find him attractive. Now, when it comes to the jury, and I'll explain the logic in a minute about how this ends up being allowed. But the jury don't hear about them kissing in the pub. They don't hear about them holding hands. They don't hear about her pulling him into the toilet. They don't hear about the pub report. The CCTV is doctored so that you only get it from later in the night and you see her staggering getting in a taxi. The witness statements are dropped. His statement is redacted. Her statement is either dropped or redacted. So all of this evidence about what actually happened on the night is dropped. Now, none of that means that he didn't rape her, right? None of that means that when he got home, it's what she said isn't true. That is true. I don't know what happened on that night. What I do know is any ordinary person would think if you're going to be able to have a fair trial, you should be able to hear the evidence of the evening and what actually happened. And all of this is dropped. And it's just, you think, well, how is that possible, right? How can you have a system that thinks it's legitimate to stop it? So he can't essentially present his story. He can't tell what happened on the evening. He can't say that this was a kind of thing that they were sexual together and we had all of the et cetera, et cetera. Anyway, now the logic, the underlying logic was too, one part of the logic is she's too drunk. Right? The idea is she's too drunk to consent. Right? And she's very drunk, definitely. And he seems very drunk as well. She's too drunk to consent. But the funny thing is that, as far as I'm aware, she said she couldn't remember anything about the evening. Right? And they knew that initially they put the toilet sex as rape, right? Because if you can't remember the evening, this is obviously not consensual. So that's part of the rape charge as well. But then when they saw the CCTV footage and all the eyewitness accounts and so on, they said, oh, we'll just drop that, right? So we'll drop that. We'll drop any mention of that so we can get rid of all that evidence. So we've just got the evidence of him going back to the house, and it's kind of his word against her word in terms of what's being said. Now, to explain in part what the logic is behind this is over the last, you can read these appeal court judges. So over the last 20 years, you've had cases where men have been found guilty of rape, and then it's gone to the appeal court and they've said, this is a mistrial and so on. And the judges, in trying to work out how to limit evidence, have come up with this kind of formal logical fallacy to justify it. And what they do is they say, well, what happened in A and what happens in B is not what happened in C. C stands alone, right? It's entirely possible you can have consensual sex at A, consensual sex at B, and then be raped at C. So why discuss A and B, right? You don't need to discuss A and B. You discuss C, right? That stands alone. And you can see these tortured discussions from these Scottish judges where they say, well, that was 4 weeks ago, right? So there's a case where a guy allegedly rapes a woman, and then 4 weeks later, she sends him photographs of herself and they have a kind of meeting and have sex. And they go, so he wants to use that as evidence as well. Why would she send me photographs and have sex with me? If I raped her 4 weeks ago, it doesn't make any sense. And say, yeah, but what happens there is not relevant to what happens here. It's a separate event. It's a different place. It's a different time. That doesn't tell us what happened in this incident. So that is excluded, right? So they exclude that. And then they have another discussion about, well, what happens? What about if it was like 2 days later? And they say, oh, 2 days later is all right. And then someone else says, no. If you're going to exclude 4 weeks as a separate event, 2 days as a separate event. And so they start to manufacture these conversations where they're trying to give a legal, logical justification for excluding evidence. Whereas really all they're doing is they're just falling over themselves to try and prevent evidence. That in their back of their heads, they're keen to increase the conviction rate, which is worrying. In the back of their heads, they have an idea that the public believe in rape myths, right? So they're constantly talking about this evidence would prejudice the jury, right? By which they mean the jury would misunderstand what this actually means. So it's like they're enlightened and they're aware and they have victim empathy, but the public don't. And so we need to limit evidence. And that's fundamentally, I think, why in the Andrew Keir case, that evidence was all limited. And why, again, it's the Supreme Court have run with it, as well as this idea, well, she's intoxicated, so she can't possibly consent. Of course, Andrew Keir's argument is that she was entirely willing throughout the evening. You could see this in the pub, you can see this in the next pub, you can see in the next pub, then we get home and it continues. And he says he forgot her name and there was some confusion about her name and this seemed upsetting. And then suddenly she got up and left. Now, I don't know if that's true. I don't know what happened on that night. What I do know is that it makes absolute common sense to think that that story about the evening obviously should be heard by the jury, and it wasn't. And now that's it. He's lost that, and he is now a rapist for the rest of his life.
And I'd have thought as well that the fact that he was originally accused of raping her in the toilet, and then when evidence came to light that didn't take his, I mean, surely that would cast doubt on other allegations.
Yeah, I mean, it's the fact that she said, I wouldn't have sex with that man. I don't find him attractive. And, I mean, I know there's not a camera in the toilet, but I don't think they were playing tiddlywinks in there. Nobody else thinks they were either. I mean, they got thrown out the pub, and there was a pub report written about it, and CCTV, and everybody, it's pretty obvious what happens here. But she said she didn't find him attractive. So, is this a reliable witness? Is her story reliable? It's questionable, and it certainly is. I mean, that's why this case was taken to the Supreme Court, because it was, the faculty of advocates and the Law Society of Scotland thought it was an egregious example of a miscarriage of justice. And they thought that because it is an egregious example of miscarriages of justice, and it has no common sense. And that's one of the reasons I'm very keen for ordinary people in Scotland to start to understand what's happening, because as far as I can tell, there is industrial scale miscarriages of justice taking place, and something has to be done about it. And that's part of the reason I got interested in the Justice for Innocent Men Scotland group, which is campaigning against this.
Yeah, and I'd have thought as well, from the point of view of genuine victims of rape, I mean, this move and the new legislation that changes the number of people in the jury and stuff, this also hurts genuine victims because it casts aspersions over convictions. It raises the doubt that possibly at some point in the future those convictions are going to be overruled because the whole system is deemed to be in retrospect failing the justice requirements. And also the changes to the jury. So I think the jury in Scotland used to be 15 people, and the jury's now gone down to 12 people. And it used to be just a simple majority. So 8 of the 15 would have to agree, and now it's a 2/3 majority. So the bar has actually been raised. Even though there's been some obfuscation around evidence that can be presented to the jury now has to reach a higher threshold of more, a greater proportion of people, believing the person to be guilty.
Yeah, yeah, it's a curious one. But yeah, I mean, the Scottish system, you'd have to look at why it had a simple majority and so on. It's because they had other checks and balances, one of which was the sort of issue of corroboration, that you need two pieces of evidence before you can ever take something to trial, which is actually, they've watered down the corroboration framework as well in rape cases. So again, they just seem to be to keep pushing and pushing and pushing. And as you say, it's the problem is that there's a real intolerance to questioning this issue, and just the very idea that you challenge the idea that we need to increase the conviction rate, or we need to question whether we should have a victim-centered justice system rather than just a justice system. All these things become relatively unquestionable, and as you say, in the eyes of the public, the law and the law courts are at serious risk of losing their credibility, because when when these stories come out, when people hear about the nature of the evidence that's being withheld and other things, I think they'll be appalled by it. Unfortunately, one of the things I find very frustrating is the mainstream media, and even the conservative media, almost especially at times, won't touch this. They seem to adopt a very similar position as the kind of victim feminist academics, and denounce anybody that questions this. And so that's what's happened to me. I've been, there's been a media pylon because I invited some Justice for Innocent Men Scotland people to talk to my students. Graffiti on the wall outside my office saying I'm a rapist sympathizer, and worse, calls for me to be sacked. A mountain of complaints and emails, so my university has to investigate. There's a demonstration at the end of this week, which is kind of like trying to put pressure on the university about me. So it's just an incredible thing that you speak out about this and invite people to speak on it. And there's a media pile-on, which to me demonstrates the problem.
Yeah, I've seen some of the social media stuff, and I think social media is part of the reason why, number one, why society and politicians are so victim focused now. Like, nobody wants to have footage going viral of them denying a victim of whatever it is something, and then they're crying, but a lot of the criticism that was of you that was blowing up on social media was very just emotive, and not at all looking at the trial system objectively, and looking at how somebody needs a fair trial. We absolutely have to have. I mean, it's enshrined in every bit of human rights legislation. We absolutely need the right to a fair trial. This emotive thing of like, believe all women. Which might sound great as a hashtag, but I mean in the trial system, let's test that belief. Let's see. We've got to find the truth, not just some blanket. If anybody says this, then they're automatically 100% guaranteed a victim, and whoever it is should go to jail, because then it just descends into a witch hunt with show trials.
Yeah, it does, and I mean, the background to this was the Justice for Innocent Men Scotland are a group of mainly women, and to some extent mainly working class women, and they bumped into each other in Barlinnie prison and just overheard one another talking about their husbands or their sons' rape trial. And they realized that there was a kind of common experience about all the flaws and all the evidence that wasn't being used, and the types of witnesses that were being used, and there's this Murov doctrine, which allows two or more people, if they say a similar thing, you can just use that as evidence to back each other up, and so on. So there's lots of things. And so they decided to set up this group called Justice for Innocent Men Scotland. And very interestingly, they try not to talk about their personal individual cases, which is extremely admirable, I think, because, of course, the thing that you would be obsessed about if you thought there was a miscarriage of justice in your family would be talking about yourself all the time, and they don't. So I met this group, and I thought, well, this is useful, because one of the things that you try to do as an academic is you try to have your research have an impact, right? So you want to try and, if you like, help other people to understand what's actually happening in the court system. And I saw this group and I thought it's a perfect example. So I kind of did that, and I met with them and so on. So I invited them to talk to my fourth year criminology class, where I was looking at my research into the court system. And of course, one of the ironies of this module is that it is a module about therapy culture and the rise of victimhood and the potential power and authority of the victim voice. And that's what I get students to look at. So I invite these women to come in, and they do a talk, and then they post a picture of themselves outside the university. And then there's a pylon. Now, the reason that there is an initial pylon is that one of the speakers had said some unpleasant things about a rape survivor activist, right? Who's online and on TikTok and so on. She's got a big presence there, and she'd sort of dismissed her, not really trusting her as a victim, not really trusting her story. So some silly things, stupid things, and some offensive things to some extent. And so when that person saw that James, just some Scotland people, had come in, she says, Abbotier is a disgrace. These people are a disgrace. How dare you allow these people into your university, and so on. And suddenly there's a massive pylon denouncing me, denouncing the university, and the university has to kind of defensively react to this, not really knowing what to do. And then there's graffiti on the wall. There's all sorts of, gutter press articles in the Daily Mail, the Times, the Dundee Courier in particular. And an investigation has started into me, pressure on me to stop my research, pressure on me to have nothing to do with James and so on. Of course, I would argue that the real reason that there was a pylon is not particularly any silly post that any of the Jim's members made. It's because just to question the narrative, right, the victim narrative, that you can only, there can only be one accepted view on this, is completely unacceptable. And the reason, and it's been demonstrated recently, because there's going to be a counter lecture by some police and rape crisis and so on. They're going to turn up at my university to do a counter lecture, and then there's a protest on Friday. And when you read the statement of the people that are organizing this, they just say, "Oh, Jims should never have come in. This was not an academic discussion. This was an assertion of facts that were not allowed to be questioned. These people, this is not acceptable. There's no free speech here." And so on. So they try and use this idea that this is some kind of a dogma being forced onto students. Of course, the irony is that I'm the biggest free speech advocate in my university by a country mile. I always encourage my students to challenge. I emailed my students to say that, these people are coming in, feel free to challenge them, and encourage them to do so in the class. And the reality, of course, is that it's the other people who are profoundly intolerant. They want me to be sacked or my research stopped. They want Jims to be, they should not be allowed to speak. And you can imagine their counter lecture, the pressure on anyone goes there. Who would question the rape crisis narrative, right? Who would question any of these? It's impossible. The pressure.
So politically toxic to go near. I mean, if I was a politician, there's no way I would 100% just be saying, "Yep, whatever these women say, yep." You know what I mean?
Yeah. So it's the real world is that if you are speaking on behalf of the victim, you are untouchable, and you will not be allowed to speak against it. And if you do question it, you will be destroyed, right? That's the real world, right? That is what I'm facing at the minute. That's the reality. My university is under huge pressure to do something, to discipline me, to regulate me, to police me, right? And that is where the power lies in society, which is why I'm interested in this issue as a sociologist, because I'm a critical criminologist who wants to look at where power lies and what is the potential authoritarian dynamic. And of course, I'm now in the middle of this. I'm like, it's like stuff I write about. I've just like dropped myself into the middle of this, and it's happening all around me. So yeah, profoundly intolerant, a real genuine. I honestly think this is. I've been writing about this for decades now. I think this is the greatest threat to academic freedom, is this type of victim narrative and victim power. And I say victim, I'm not talking about victim. I'm not talking about victim as an individual. I'm talking about it as an ethic. Right, it's not quite an ideology, I don't think, but it's a kind of it's a sentiment, and it's a way of being, and it's a way of thinking about other people, which is always tends to be protective. That you need to protect people, and in this case, you need to protect people from ideas. You need to protect people from different types of groups, and people that might think differently. So yeah, that's where we are at the minute. So it's a perfect storm. You've got this going on with me, and you've got the Supreme Court ruling coming out of this at the same time, which is, it's kind of contradictory, because it's thrown Andy Keir under the bus and said, oh no, we're not going to touch that. But at the same time, it has said, yeah, Scotland's gone too far in the restriction of evidence. But of course, now you're getting a counter to that, where I think it's Dorothy Bay and some other senior people are coming out and saying, oh, no, we're going to protect victims, because there's now a backlash to this, saying, rape victims are going to be scrutinized, traumatized, re-traumatized, and so on. I mean, trauma is another thing we could talk about, but anyway.
Yeah, and I guess another time we could talk about the history of politics and sexual assault accusations in Scotland, because of course Alex Salmond was deposed, was dethroned and thrown out of public life as a result of accusations against him that a lot of people on his side are saying were unfair or untrue, and there was a lot of finagling around that involved politicians and the criminal justice system, and a bit too much of a sort of overlap between the two when they should be separate columns. But yeah, I mean, thanks so much for talking to me, Stuart. That's really interesting, and I really hope, on behalf of those that are wrongfully accused, and on behalf of victims, the actual genuine victims, not people wearing the cloak of victimhood to score political points. I really hope that you persevere, and congratulations on standing up and speaking out, because I wouldn't.
Yeah, well, I mean, I'll just say, and I'm not saying this defensively, I'm saying this because it's obvious that every rapist deserves to go to prison, and every man deserves to have a fair trial. Both things are true. Right? It should not be difficult. It might be difficult in terms of where you try and get the balance in court, and judges should be able to use their judgment. We don't live in the 1970s or the 19th century anymore. We've got a modern sensibility. Nobody wants these women to be brutalized in court, but you cannot continue down this road of restricting masses of evidence that completely undermine the basis of a free trial in Scotland. And at the minute, that's where we are.
Yeah, absolutely. And is there anywhere you'd direct people to learn more about your work and about Jim's?
Yeah, well, go on Facebook and look up Justice for Innocent Men Scotland, and they've got a website. I've got a paper, an academic paper, which you just put up Stuart Waiton rape jury or something like that. That comes up in Sage. Got an article in the Spectator, and I've got a draft paper that I'm going to have to rewrite. But if anyone's interested in the draft paper, they can just email me at Abertay, which is my university, which is s.waiton@abertay.ac.uk, and I'll send you a copy of that paper.
Okay, brilliant. Thanks so much for your time, Stuart.
Thanks.